Look, she tested positive yesterday. Don't we need to do a drug test? Make sure that she's negative.
Well, I mean, how long did it take to get out of the system? So
Just because it's in her system doesn't make her intoxicated.
no,
I understand.
Anyway, she's been overnight.
Are y'all insisting that we move forward together?
Good. I mean,
And there's
a reason.
you've spoken to it.
Oh, yeah,
If
exactly.
there's any reason to believe that the defendant is incoherent or does not understand the proceedings.
No, she understands here.
Ms. Milton, you understand where we are and what we are doing?
Yes, sir.
Okay, and Mr. West is going to help you on this. You were charged in 2 cases, 23 CR 905, forgery of with a financial instrument, that is a state jail felony, and 23 CR 907, which is fraudulent use or possession of identifying information, and that is also a state jail felony.
Notice how the judge is clearly laying out the charges. 2 state jail felonies. This is a critical moment because the defendant now fully understands the stakes. Up to 2 years in jail and $10,000 fines. Courtroom tip. Understanding the charges is essential for any plea decision. No room for confusion here. Imagine the tension for her. One wrong step and these consequences become very real.
The defendant waive formal readings of these indictments and arraignments. Can we proceed in summary?
Yes, Your Honor, please.
In summary, each of these indictments similarly state that on or about January 31st, 2023 in Jefferson County, Texas, you committed these state jail felonies that I described for you in these cause numbers 23 CR 905 and 907. You understand from speaking with your attorney what you were charged with in each of these cases.
Yes, sir.
These are state jail felonies, which mean that you face no less than 180 days, up to 2 years in the state jail, and a fine up to $10,000 can be assessed for each case. Do you understand?
Yes, sir.
I don't know what he's doing. Agreements have been reached. Well, even to the record, we're fixing the pad.
Yes, Your Honor, the agreement is on each case, 5 years to probation, $500 fine, no restitution and impairment.
All right. Or is it your understanding, as Mr. West has just read out loud, that the plan is you would be pleading guilty on each of these cases, not found guilty, but placed on deferred or unadjudicated probation for up to 5 years? And was there a fine? $500 fine in each case, and there would be terms and conditions of probation, which is normal and customary for this type of offense in each case.
Here's where it gets interesting. The plea deal offers deferred probation instead of immediate conviction, meaning the defendant avoids jail if she complies. But notice the catch: no right to appeal. This is standard, yet so many defendants underestimate how binding this is. Rhetorical hook for viewers. Would you risk going to trial or take the safety net? This is the kind of decision that can change her life.
Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead in each of these cases, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will, and because you are indeed guilty of each of these charges in these 2 indictments.
Yes, sir.
I'm going to show you in each case what's marked as State's Exhibit 1. Did you sign these documents?
Yes, sir.
Understand them? Discuss them with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 was tendered into evidence in each case.
No objection.
Without objection, admitted. Among other things, they state that you are mentally competent to enter your guilty plea. These are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read it. You're
Pay attention. This is the legal heavy lifting moment. By waiving her rights, the defendant is giving up jury trial, witness confrontation, and cross-examination. In layman terms, she's saying, "Judge, I trust the system to handle this fairly." The court takes her competency seriously. Her answers confirm she fully grasps the consequences. This protects both her and the integrity of the proceedings.
guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights of the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true, it states, so help you God.
Sir.
Is that true?
Yes, it's true.
Let me tell you, this pad is
Here, switch with me.
it's
The battery's really low on there. I should be like that since pull up what you need.
yeah, it doesn't want to pull up right
Yeah.
now. It's
No, it wasn't charged. Nobody do one at a time. So leave mine.
Fine, 500 on each.
it's not working. This is not working.
So do you think it's not?
I don't.
Whenever you get out. Oh, 05? Are we on 07?
I think it's 05. Keep trying to open.
You do 07.
I did. I think I already did 07, and that closed fine. Check it.
Yeah.
I don't have any of them back to you because I'm not logged in.
You see your initials on them.
Yeah, they're locked with things.
Stand by, everybody. Smoke them if you got them. What's the problem on this thing? Is it me?
Loosen up behind the wheel.
Or you're walking the rest of the trip? All right. In each of these cases, ma'am, I show you what's marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney, or the contents true and correct? Yes, speak out. Yes, they're all true and
Yes,
correct. Okay. State's Exhibit 1 is tendered into evidence in each case
No objection.
without objection admitted. And again, these state that you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confirmation, cross-examination of witnesses. God bless you. You are totally satisfied with the representation provided by your lawyer. All true, so help you God. Sure. State's Exhibit 1 in each case made a part of the record for all purposes. Pre-sentence reports waived.
Please, John, yes.
I am going to follow these agreements. If nothing further, I'm going to find you, ma'am, Ms. Milton, you are pleading guilty in each of these two cases voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt in each of these cases. But I'm not going to find you guilty so long as you follow these terms and conditions of probation. You will be placed on deferred or unadjudicated probation for 5 years to run concurrently at the same time. You must pay a fine of $500. There will be other terms and conditions of probation, which are normal and customary for this. Make sure you follow these. If you fail to follow the terms and conditions of probation, your probations could be revoked. You could then be found guilty of the.
And here's the dramatic finish. If the defendant fails to follow probation terms, she faces full conviction and potential jail time. This is why probation is not a free pass. It's a second chance. The judge's clear warning emphasizes her personal responsibility. For the audience, think about it. These moments define the line between freedom and incarceration. Small decisions now can have huge consequences for her.
These felonies and sentenced up to 2 years in each case. Okay. Oh, you're going to do well, aren't you? All right. Fix this, and the probation officer will go over all of this with you here in a moment. Thank you.
Oh, that's what you want.
Yeah.
I need comfort.
Yeah. Oh, very good. Yes, she's only needed to finish up the rest of it. Actually, this is very